Served for a $12,000 credit card you never opened. Different middle name, different date of birth. They still sued. Here's how you handle a wrong person debt lawsuit. Okay, I heard recently from a lady that in August they received a letter from a debt collection law firm for a $12,000 credit card debt. This lady never had that credit card. She called the law firm, spoke with one of the representatives, and explained that she had the same first and last name as the debtor. The middle initial and date of birth were different. The law firm representative said they were going to mark the case as fraudulent. It was all fine. Last week, that lady was served with a lawsuit from that same law firm debt collector. Okay, that complaint indicated that mail was sent to someone who lives in the same city, has a different address, different middle initial, and that different date of birth is mentioned. The lady's wondering, how should she go about handling that? My name is Patrick Nolan. I'm an attorney in Missouri. I have been an attorney for more than a decade. Prior to that, I was a debt collector. I worked for IC System and managed a medical debt team for NCO. And then I did some private debt investing where I purchased debt and I sold debt packages. So I have a little bit of experience in this. You know, she wants to send a letter and handle it outside of court, which going outside of court is always a good thing. Okay, and the very last thing in the message was if they decide to go to court, so you've been served. They are already in court and you have missed that entire argument. The game is afoot. You have to play the game now. If you don't, you're going to lose by default and you're going to owe $12,000 that you never owed. Doing this correctly is more important than the phone call that you had with the collector in August. So right now there are steps that have to be done. And if you're in a similar situation, read the service you received completely, start to finish. Read it beginning to end, make a note of everything. Note your deadlines. You have a deadline to answer that. In your jurisdiction, it could be 15 days, it could be 30 days. Make sure you notice and find out what your deadline is to answer. If you don't answer, you lose. So make sure you put it on your calendar that deadline, then you can prepare the answer and file an answer. When you're filing an answer, you are challenging each and every obligation or each and every declaration they made. You know, you are a person that resides at this. You borrowed this money from that entity. You did X, Y, and Z. Okay? When you're answering it, you are either admitting or denying each statement. And if you don't have enough information to be able to admit or deny, you say, lacking information, I'm unable to admit or deny and therefore must deny. Then you have to file that answer in the correct way. You can look at the court rules. Most courts have them available online, but look at the local rules and then you file your answer correctly. File a copy with the court and serve a copy on the plaintiff per the court rules. It's not overly complicated. You can do it. Then you have to start the discovery process. If this is before suit, you're going to request validation. Validation is a process under FDCPA where you can request that they validate that this debt is correct and it is yours. To demand proof that you owe this debt, what you're basically doing, you're in court. It's called a discovery process. You want to send requests for production and interrogatories. Frankly, at this point, you need an attorney. If you don't know what you're doing, it's very easy to make a mistake and lose. If they send you discovery, you have to answer it completely, fully, and correctly. If they send you requests for admissions, you have to answer them. Or everything that they're alleging is deemed admitted and you've lost. This lady says she identified that the person they were trying to reach actually lived in her town, which is phenomenal. But document that. Get proof that lady is living there and you can offer that to them or provide it in discovery. But you want to make sure that everything that you are getting is something you're going to be able to present in court. You have to be able to lay a foundation for it. Is that evidence admissible? You know, just because you said you talked to somebody, that's hearsay. That's not admissible. It's an out-of-court conversation for the purpose of proving a fact. You can subpoena the person that you talked to and ask them the questions again under oath, but you can't simply say what they said. pull your credit reports. You want to pull your credit reports right away and make sure that this debt isn't being reported on your credit and that you don't have any other fraudulent entries. Okay, you can place a fraud alert or a credit freeze, and you can go through the process. If you see something on your credit report, it shouldn't be there. Every communication that you have had with that debt collector, the debt collection law firm, every communication, letter, email, phone, document it, log it, pull your phone records out, record the date, time, and the length of the call. You want to make sure that you have all of that so that you can prove and support anything you're saying with records. Really, there are lawyers that practice personal attacks all the time, and there are lawyers that present the receipts. Okay, I am a receipt guy. Everything that we present that I want to pull testimony to, I want to have at least 2, preferably 3 to 5 sources for that statement. It comes out of my journalism background. I want to be able to prove everything that I'm saying, and by doing that, we're able to discredit something someone else is saying that is incorrect. If this is egregious and they're continuing to press on despite your proving that they have this wrong before the actual trial date, then it's time you really need to consider a consumer law attorney, and you may want to consider potential FDCPA or state law violations. The FDCPA is the Federal Debt Collection Practices Act, but talk to a consumer law attorney about that. Absolutely do not go into a case where you could be held liable for thousands of dollars without an attorney. Even if all you do is go and consult with one, pay a couple $100 for their time and make sure you got your ducks in a row. Now, why does these kind of mistakes happen? Look, high volume debt litigation, the information gets sloppy. The reality is a package of debt from a creditor is sold, or it's transferred to their collection agency, their first round collections, and then next it'll go to a tertiary collection agency. At some point in there, it may get sold, get packaged up, and then sold for 10, 20 cents on the dollar. It still has value at this point. The debt is usually within a year and a half to 3 years old. After that, then that next owner will place it with a collection agency or put their own calling center on it if they have one. They'll work that package, they'll make what they can off it, and depending on what their metrics are, they could say, we're going to work a package for 6 months, and then we're going to sell what's left. It's a good strategy. I've done it. And then it goes down the line to lower and lower tier collection agencies. I bought a package for a half cent on the dollar. It was really crappy debt package. The documents were next to non-existent, but I made about 20 times my money on that before I sold the remainder of it. It is a high dollar industry. Okay, when you get into court, most of those cases are won by default. Simply showing up to defend yourself changes that script and flips it around on them. Deciding when you need to lawyer up, if it's a larger amount or there's credit damage implied, or you believe there's identity theft, or frankly you're out of your depth on the procedure and how to defend yourself, you need a lawyer. At the very least, you should always consider finding a lawyer that will sit down and go over it with you and help you map out your case. If you're going to defend yourself, at the very minimum you need to do that. It'll cost you a couple $100 for their time. Do it. You're not powerless in this situation. Answer the lawsuit on time, demand discovery, protect your credit rating, and go for your countersuit if you have one. I have a checklist that I have prepared on how to respond to a debt collection lawsuit. The link is in the comments. Please feel free to go and download that. It's no charge, it'll be free. That'll be hosted on my law firm's website. Understand though, you download that, there is no attorney-client privilege. I'm not representing you. That is just information for you to use and help educate yourself. Please like, subscribe. Thank you.